everybody. I'm sure it looks like you're all very excited about PWD. That's right, the prevailing wage determination process. And of course, the timelines, pitfalls, and a lot of questions in your mind, I'm sure. And hopefully, that you've joined this episode, your doubts will be cleared very soon. So stay with me to find out. All right, let's go for a break. Welcome, everybody, to Immigration and Jobs Talk Show with me, your host, Nipasa Pradhan. And today, as I said a little earlier, we'll be speaking about PWD, the prevailing wage determination process, the timelines and pitfalls. And of course, we'll have most of our questions as well cleared. And, we'll be joined by none other than immigration attorney Prashant Dubey from the law offices of Dubey Law Offices. And we'll be very happy to have him here. And this show, by the way, is being aired live right now. It's going live on YouTube, LinkedIn, and Facebook. So wherever you're watching us, if you have any questions directly to the attorney, don't forget to comment your questions there, and we'll be very happy to answer. So let me just tell you that it's going to be a short show, probably an hour or so. And in the first half an hour, we'll try to cover up questions and everything else that we want to know about PWD, the prevailing wage determination process. And yes, attorney Prashant Dubey had joined us last time in the first episode, to brief us about the employment based green card. And today as well, we'll be speaking more about it. And without further ado, please help me welcome him to this show. A big hello to you, attorney Prashant. Thank you so much for joining us today.
Yep. And thank you for having me. So thank you to the Higher IT team. Thank you, Nipa, for hosting the show today. As you've mentioned, I'm Prashant Dubey. I'm an immigration attorney based out of Washington, D.C. And I've been practicing immigration law for the last 5 years now. And a majority of my practice includes employment-based filings, right? So this can be H1s, L1s, E-visas, for example, as well as the GC process when it comes to employment-based petitions. And that includes the prevailing wage determination, which is the topic of today's webinar, of course, the Perm filing and the I-140 and 485 applications as well, which come much later in the process. But I hope I can make the PWD process as exciting as you have introduced me. So I'll do my level best to keep things interesting and hope no one falls asleep during this holiday season, right? Because it is starting to feel very cozy outside. I know the weather here is starting to get cold, and we're expecting some winter weather, so that's always interesting. But thank you for having me.
Absolutely, absolutely. It is the holiday season. We're all cozied up and probably some hot chocolate sipping into it. And yeah, the Christmas season is here, and I think people out there are also very excited to be more successful and everything. So, last time, you joined us to speak about the employment based green card, and today's topic is, of course, like we said earlier, the PWD. So, what is it? What is PWD? What is prevailing wage determination? And maybe you could also catch up on the essential, why is it so essential, for the employment based green card applications and even the regulations for it. So,
Yeah, absolutely. So prevailing wage determination, or as we say, the PWD, so that we don't have to keep saying prevailing wage determination here today.
yes.
It's also known as the ETA 9141. And the ETA 9141 is the form that is used to actually file the PWD with the Department of Labor, right? And it's important for a few different reasons. One being that it is the very first initial step of the perm labor certification process, right? So when we submit the ETA 9141, or the PWD as it's better known, what we're telling Department of Labor is that an employer is willing to hire and sponsor someone after they've got a green card in various employment based categories. And in the 9141, what we list out are various job responsibilities, any specific skills that are associated with the job, any specific education requirements that are necessary in order to do this job. And we submit all of those details to the Department of Labor. And what they do is they issue a prevailing wage. And what that prevailing wage is meant to do is essentially say, hey, this is the appropriate wage level for this particular job based on all of the job requirements, all of the skills, all of the education, all of the work experience that you have listed out in this form. And really, it's meant to protect foreign workers, right? Because it makes sure that you're not being paid below a certain wage level based on those requirements. And it's also meant to protect domestic workers to make sure that there aren't any workers within the United States who are capable of doing that job who would be displaced, by this type of sponsorship. So, in a nutshell, to summarize, the ETA 9141 is meant to obtain a prevailing wage for a specific job for a specific individual at a very specific location based on job requirements, job skills, education requirements, and work experience.
All right. And since we're talking about it, maybe you could tell us about the ways to file it. Online, paper, how do people go about the whole process of applying for it?
Yeah, it's very straightforward in the sense that the Department of Labor has created this flag system online, right? So you can submit a case or an application for the 9141 online. I don't know why anyone would want to do this by paper when, the online capabilities exist where, an employer or maybe the employer's attorney already has an account on the Department of Labor flag website. All they need to do is just go to cases, open up a specific application for the ETA 9141, and then they simply submit it, right? It's a very straightforward process once it's done online.
Awesome. That's true, actually. And maybe you could also tell us about the timelines, the current timelines for PWD determination. Well, of course, I think we'll catch on it earlier, a little later, but we have something on the screen which is about USDOL. So let's talk about it and also the NPWHC fee for PWD.
Yeah, yeah. So all these acronyms, right? The USDOL is the Department of Labor, right? The United States Department of Labor. Within the Department of Labor, there's an organization called the National Prevailing Wage Help Desk Center. And basically, what the NPWHC does is they are the ones that actually issue a determination or a prevailing wage on the ETA 914.
Okay. All right. So let's hit on to what PWD determination, the current timelines, for the determination of PWD. It used to be about 45 days. And what about nowadays?
Yeah, excuse me. It's definitely not 45 days anymore, right? So typically it should only take about 3 to 6 months to get a PWD back, right? I have seen instances, I think there's a case that I did myself where it took about 13 months to issue the PWD from the Department of Labor, right? At about month 11, we got a request for information or an RFI from the Department of Labor, where they basically said, hey, look, we see that you're sponsoring this individual for a business analyst role, but we feel like we don't have enough details about the job, right? And so they issued an RFI where they asked for more information. They wanted us to get a little bit more granular in terms of the job responsibilities. And then it came back, approved, or the PWD was issued about a couple of months later. But typically, it should only take about 3 to 6 months. There have been longer and longer processing times, I would say, over the last couple of years. So don't be completely shocked if, a PWD maybe takes 8 months or 9 months or even pushes close to a year in some instances.
So it really delays. I mean, I was thinking 45 days is long, but then you're talking about 13 months and 6 months, and it's really long. Why these delays, though? Is it the same for everyone? The reason?
Yes, right. So at least for the Perm's labor certification process, right? where you fall on that timeline of whether you're 3 months, 6 months, 9 months, or 12 months, you're never really going to know. It's a matter of when the officer at the Department of Labor, picks up your file, takes a look at it, right? And again, some individuals get it very quickly in that 3 to 6 month time frame. And there's some individuals
Mhm.
that do end up waiting 8 to 9 months just to get a PWD, right? So if you think about the length of the Perm labor certification process, in and of itself, it can take about 12 to 18 months end to end from PWD to Perm to I-140 filing, right? And getting an approval back on that. And that's if you're staying within the average timelines. If your PWD itself takes about a year, you might be looking at a Perm labor certification process that's going to take 2 years, right? Because the Perm process itself can take about 6 to 8 months, and that's pretty common, right? And that's
Mhm.
if you don't get audited at the Perm stage. So, there's no consistency, unfortunately. And I wish I had a better response to that or a better answer to that. But, that's kind of the ambiguity that immigration attorneys live in. And so do employers, when they're going through this Perm labor certification.
Mhm. Hopefully, though, these delays will shorten up and maybe won't take that much long anymore.
Yeah.
Anyway, so do you think the PWD indicates the green card?
It does not, right? So, and I want to back up a little bit, right? Because like the very initial step, almost at like a consultation phase or consultation stage, when I'm meeting with a client or an employer, one of the first things we talk about is, what is the beneficiary, right? What is the employee's qualifications? Really, the determination of an EB2 versus an EB3 is going to happen, at least for me, and probably most immigration attorneys in that initial consultation, right? Where we decide, hey, based on the job profile, based on the job responsibilities, based on the individual skills, based on their experience, based on their education qualifications, where do they fall, right? EB2 versus EB3. From there, right, we take all of that information and we put it into the ETA 9141 or the PWD, and get a prevailing wage. So at the filing of the PWD, we're not deciding at that point, or at least indicating to the Department of Labor at that point that this is an EB2 versus an EB3 application, right? Um, Even at the Perm labor certification stage, we are not indicating to the Department of Labor of whether it's an EB2 or an EB3. It's only at the I-140 stage, right? The petition for alien worker, where we're actually telling USCIS that, we filed these applications, we've done the requisite recruitment, and now we're informing you that, hey, look, this is going to be an EB2 professional or an EB3 skilled worker, right? So again, at the very initial consultation, we are making a determination internally. But when it comes to the Department of Labor process, there's nothing that we're informing them about in terms of EB2 or EB3. That only really comes when USCIS, United States Citizenship and Immigration Services, when they come into play and the I-140 application is in play, that is when we indicate whether it's an EB2 or an EB3 application.
Okay, wow. It's very deep, and everything is so detailed, and it's lovely to get to know. I mean, it's definitely eye-opening so far. We've got a lot to talk about, Attorney Prashant, today, and thank you so much for answering our questions so far. And I hope the folks out there are also having a good time, and are getting a lot of knowledge from Attorney Prashant himself. And thank you, all you folks out there in YouTube, Naseem, Omnisa, Prasad, Alex Bose, Seema Singh, so many of you all. Thank you so much. Hi, a big hello to all of you. Thank you for joining in, and keep dropping your questions. We'll be very happy to answer them in the second half. So until then, of course, just stay tuned with us. We are speaking with Attorney Prashant Dubey today from Dubey Law Offices, and we'll just go for a short break now. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everybody, to Immigration and Jobs Talk Show with me, Nipasa Pradhan. And today we are speaking with attorney Prashant Dubey about PWD and employment-based green cards, the whole process. We've been touching up on a lot today, from EB2 and then the timeline of PWD and also the whole process. Why does it take so long? But we are still got a lot to talk about, right? I hope you're having a good time, Attorney Prashant, today. Thank you so much again for joining us.
Yeah, no problem.
So my
Thank you for having me.
yeah, my next question to you today is, the priority date, decided based on PWD date or perm filing date. This is a
It is
question
based.
actually by Raj Purohit. Thank you so much for the question, sir. Tony, please.
Yeah. So the priority date is based on the perm filing date. I wish it was the PWD date because then, you would get some additional time back, when it comes to priority date. But the priority date is based on the perm filing date.
All right. And I think we have another one, which is by JBR Prasad from YouTube again. What will be the time frame for H1B transfer if we want to change our current company to some X company?
Okay. You can do that in premium processing, right? So, it can be as little as 15 days. It can be as much as 6 months if you opt not to do premium processing, right? So, when you're going from employer A to employer B, and employer B is filing an H-1B transfer application for you, again, it can be done in as little as 15 days if you opt for premium processing, which is what I recommend, or it can take as much as 6 months if you do normal processing.
All right. Thank you so much for answering that question from YouTube. JBR Prasad, I hope you got your answer from Attorney Prashant himself. And all right, I think let's move ahead with our questions today, Attorney Prashant. I have something to ask you, and that is about, how is the PWD determined, and who sets the wage standards?
Yes. So really the PWD is defined as kind of the average wage paid to individuals that are employed in a similar occupation, right? In a very specific location or metropolitan area. So again, I'll repeat that. It is defined as a wage paid to other workers in a similar occupation. So let's say if you're being sponsored for a software developer position, DOL is going to look at what are other software developers paid in, for example, the city of Alexandria, Virginia, which is where I currently live, right? So they're going to look at your specific county, your specific metropolitan area. They're going to look at the occupation and how do you stack up against other individuals who are in that same occupation, SOC code, that sort of thing. Now, that's also where you see a lot of differences across wages, right? Because an individual sponsored for, let's say, software development position in San Francisco, in New York, and Washington D.C. is obviously going to have a much higher wage level than, let's say, someone sponsored in the state of Florida, right? So
Right.
when issuing that determination, very generally, the Department of Labor will look at education, experience, special skills required for the job. any supervisory responsibilities, and then kind of taking a holistic look at all of those details, they will then issue the prevailing wage.
All right. All right. Thank you so much for answering that question. And I'm sure folks out there would also want to get in touch with you directly, so if you could share with them your email or wherever they could get in touch with you, Tony Prashant, it would be really great.
Sure thing. I see it flash across the bottom of the screen
Actually,
right now. That was timely. I did nothing.
that's
Thank
magic.
you, team.
But yes, I mean, folks out there, you can note down Attorney Dubey's info@dubeylawoffice.com. That's his email address. So if you have any queries, anything directly to Attorney Prashant Dubey, you can just drop him a message there, a mail there. All right, let's move on to the next question, and that's within our topic again, PWD. So, my next question is, any reason the PWD can be denied by NPWCH? If yes, what are the alternatives and any appeal process?
So it's possible, right? A PWD, if it's very high level, very general in nature, right, doesn't really get to the specifics of a job or the skills required or the right amount of education required. An officer at their discretion, they can deny the PWD. What I've seen though, um, is they typically issue what's called, again, the RFI, the request for information. So if they feel like, hey, this job description, and I find that people that tend to get sponsored for like business analyst roles tend to have very general job descriptions, and um, the level of granularity that's needed can really be lacking there. If they find that it's not specific enough, and it doesn't, the work experience required isn't matching up, with the job responsibilities, they'll probably issue an RFI, give you another opportunity. And if in that second opportunity you don't get granular or you can't justify the level of experience or education required for it, they can reject it. And that's totally normal. In terms of the appeals process, I am unsure, right? I've never had to appeal a PWD decision. I've always had them approved and the wage level issued. So I'm not going to answer that question because I've never had to face it. And if there is a process, I'm not familiar with it. Um,
Mhm.
if anyone does have a question about that or a follow up, I'm happy to take that back, get the requisite information, and provide a more accurate answer. Now, I do know that at the Perm labor certification stage, if that gets denied for whatever reason, you do have an opportunity to appeal. We tend to see more denials at the Perm labor certification stage, right? That is step two of this process. We tend to see more denials there, or more audits there, and they do have a formal appeals process. But for the PWD, I have to take that one back.
All right, I think we have something about it. Someone commented in YouTube, and she's Twinkle. Um, I've approved I-140, return to India, changing jobs. Can I use the approved I-140 from the previous employer to file an H-1B with the new Indian company? Or do I need documents from the previous employer?
As long as you have a copy of your I-140 approval notice, right? It can even be a courtesy copy. That's fine. The kind they send to the attorneys. As long as you've got a copy to show that, hey, look, I do have an I-140 application that's been approved, you can absolutely use that, in order to do an H-1B transfer. Let's say, perhaps because you've already maxed out on your initial H-1B and you're looking
Mhm.
to extend beyond those initial 6 years, perhaps that's the reason why you need to do this. But yes, you can use the previous I-140 application, so long as your employer never revoked it within 6 months of your I-140 application being approved, and you can leverage it to move to employer B. But other than the I-140 approval notice, and just making sure that it wasn't revoked within 6 months of approval, um, you're absolutely fine, to do the H-1B transfer.
All right. Thank you so much for answering that question from Twinkle in YouTube. Thank you so much. And Twinkle, I hope that you got your question answered, and I hope your doubt is more clear now. Let's take up another one from YouTube, and this one is from Thomas Shah Nisa, if I'm pronouncing it right. Hope I am. And he says, after PWD approval, what's the minimum time to file perm for EB2 or 3 in software engineering? The company cites 3 months, sorry, plus potential cooling periods. Any insights on cooling times without layoffs?
Yeah, yeah. So it's not specific to occupations, right? So whether it's a software engineering role, business analyst role, none of that really matters, right? In terms of, let's say your PWD gets approved, every law firm, every employer does this differently. Typically, what happens is there's a recruitment period that starts, and that typically lasts about 30 to 40 days. After that, there's this cooling off period that the individual is referring to, where let's say you've, put all your advertisements out into the world, in the newspaper, in a job posting website, you've maybe run a radio ad. There's this cooling off period of 30 days where the employer needs to wait. After all of those recruitment activities are done, they need to wait an additional 30 days just to make sure that there isn't going to be somebody else applying to the job from the American workforce. So if you have a very agile attorney or an agile employer, at max, the perm recruitment should only take about 60 days, just about. Now, they might take some time to prepare the ad paperwork, reach out to the agency that's going to be running the ads, and that might require another, 1 or 2 weeks of preparation if they haven't prepared it already. But I would say 60 days is just about right. The way I look at it is if a prevailing wage determination has been filed, it's pending for 3 to 6 months, let's say, that's plenty of time to get together all of the advertisement paperwork such that once the PWD is actually issued, you can jump right into recruitment, right? And you kind of minimize any gap or waiting time. So again, I would say about 60 days is what an employer or attorney would need, but 90 days in isn't bad either, right? Not an egregious amount of time to have to wait.
Yes, that's right. So, Thomas, Shanisa, I hope you've got your answer too. And I hope that if you have any more questions, definitely just keep commenting your questions wherever you're watching us, whether it's YouTube, LinkedIn, or Facebook, your favorite handles. And we are here for another half an hour or so, or maybe less, with Attorney Prashant Dubey. He'll be here to tell us more about PWD, what we're talking about today, the GC process, and a lot more questions by you who will answer. Let's just go for a short break now. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, all you folks out there, to Immigration and Jobs Talk Show with me, Nipasa Pradhan. And in today's episode, we're joined by Attorney Prashant Dubey from Washington, D.C. And he's here talking with us and getting our doubts cleared about PWD and a lot more that we have been discussing here over the past half an hour. Thank you, all you folks, for joining in today again. Let's go continue. And without further ado, I think I'll just jump on to the next question for you, Attorney Prashant. And by any reason the PWD can be denied by NPWCH? And if yes, what are the alternatives?
Yeah. So I think we covered this one earlier.
Yeah, actually,
Um,
we just did.
yeah.
But
So I don't know if we want to go to the next
no,
one.
that's cool. That's cool. We'll move on to the next. But if you have anything to add, we can just add right now.
Nothing to add to it. Again, it is possible. A USCI, sorry, a DOL officer at their discretion can in fact deny or refuse to issue a prevailing wage for an occupation if, for example, the job details are not granular enough, or if they feel like the job requirements or the education level doesn't match up with the job description, right? So, I've
Mhm.
sometimes had clients that will approach me and they'll say, "Oh, my PWD, I faced some issues with it, or I got an RFI for it," and it's because the employer and the attorney were requiring an MBA for like an IT help desk associate position, right? Like it just doesn't add up. And so typically in those instances, a DOL officer they will issue that request for information to get additional granularity or clarification. But yes, they can absolutely deny um, a, a prevailing wage or refuse to issue it.
All right. And thank you once again for clearing that for us the second time. Let's move on. Yeah, I want to get an answer to this one. Any legal alternatives in lieu of filing PWD with the USDOL? For example, employer wage surveys, etc.
Yeah, so there are alternative wage surveys, right? So typically, what happens is when we file a 9141, we're telling the Department of Labor that we would like you to go and look at your own internal resources, your own internal statistics and wage data, and issue us a prevailing wage based on that data that exists, right? In
Mhm.
some instances, probably like 5 to 10% of the time, an employer, may opt to go and get their own private survey, right? Where they will take a look at, alternative statistics. And this can be from your state's workforce agency, this can be from your state's Department of Labor, or state corporation commission, anywhere that private workforce data might exist. You can lean into it, you can access it. They tend to be expensive, so employers don't always opt for that option. And one thing that the Department of Labor is going to look at is, was this survey done based on employees or workers that are within the same area of intended employment? Is it capturing that information? Um,
Mhm.
are the individuals that were part of this survey, were their job responsibilities similar in nature, right? um, in
Mhm.
terms of the data that was collected, how was it collected? Was it used, or was it collected based on the right statistical measures, right? So Department of Labor is really going to go through that with a fine tooth comb, and almost with a magnifying glass when employers opt for an alternative wage survey, just because you're kind of going outside of their normal processes, their prescribed processes. And not to say you can't, it's just 90% of people usually don't, right? So there might be some challenges with that, where again, an RFI can be issued where they try to ask you for more information about that alternative survey and where you got that information, how you got it, how did they get it, and
Mhm.
that can be a challenge.
All right. Thank you for answering that. Let's move on without further ado, since we're running short of time, and there are a lot of people watching us, and they have a lot of questions, so we'll get to them as well. But yes, the question is flashing on the screen: new Perm online process and data pull from PWD. The new Perm online filing automatically pulls data from PWD. So, what if there is some change in job duties or proposed employment? What are we going to do?
You're going to restart the process. So the thing about this, right, and the reason why it's such a delicate process is because every single part of it, every single step needs to be strung together. And what I mean by that is when you start with the PWD, you're saying to the Department of Labor, you need to issue me a prevailing wage determination based on these specific job duties, these specific responsibilities, and based on this individual's experience and education, right? At the perm labor certification process, and also slightly, I would say, step 1.5 at the recruitment stage, you are saying the same thing. You are taking the same details you put in that PWD, you're advertising based on it, and then you're going to the Department of Labor, filing a perm labor certification and saying, this is what I recruited on. There's no one else in the US who can do this job but this guy, right? This one individual employee I have who can do this job based on his specific unique qualifications. And you submit that in the perm labor certification application as well. Then that comes back submitted. It then goes to USCIS. USCIS scrutinizes it. They take a look at the PWD job responsibilities there. They look at the recruitment paperwork. Were there any changes? They look at the perm labor certification. Was recruitment done accurately? Were the job responsibilities consistent across the PWD and perm stage? And then at the I-140 stage, they're also going to look at, well, where did this individual get all of this work experience that qualifies him, and he's got all the unique experience to do this one job in this one area for this one employer, right? And so that's where like experience letters come into play. So there needs to be consistency across the entire process. If at any point it becomes inconsistent, you raise your chances of an audit at the perm stage, you raise your chances of an RFE or request for evidence at the USCIS stage, and at the end of the day, you do increase your chances of potentially a denial and your entire one process falling apart, right? So, as a best practice, you want to make sure that the job responsibilities, the job duties, the skills, all of those things are staying the same from beginning to end so that you don't have to restart everything.
All right. So the new perm online process, and that's on PWD, folks out there. I hope that you are getting most of the information cleared. And if there are any confusions or you are in a very different position which is very hard for you to get an answer by yourself, maybe why not drop in your questions in the comments wherever you're watching us, YouTube, LinkedIn, or Facebook. Just drop your questions in the comments, and we have attorney Prashant Dubey from Dubey Law Offices, Washington DC, to answer to our questions. And I think let us go ahead to the next question that we have for you today about PWD, attorney Prashant. So a PWD, is beneficiary specific, or can it be used for multiple beneficiaries?
So it's unlike a labor condition application, right? So typically, when an individual or an employer files an LCA, they have the option to sponsor multiple beneficiaries and H-1B applicants within a single LCA. Now, with the PWD and the PERM process and the associated I-140 process, you do not have that option, right? So it is unique to one individual, one company, one location, one set of skills, one set of job responsibilities, et cetera, right? So it cannot be used to sponsor multiple beneficiaries. It can only be used to sponsor one beneficiary end to end.
All right. So no multiple beneficiaries, just one at a time. All right. And folks out there, I also have gifts for you. So wherever you are participating from, you're maybe dropping your questions. Yeah, I have a lot of holiday gifts like wireless chargers, backpacks, power banks. All you've got to do is mail me at nipa@higheritpeople.com, and I will mail them to you. It's very, very exciting. So tell us where you're joining us from. Tell us about yourself and your question, of course, based on the topic we are discussing today, and mail me at nipa@higheritpeople.com, or you could just WhatsApp me or call me in the number 408 335 6444. And yeah, stay with the holiday spirit, I guess. So moving on, let's go ahead speaking with attorney Prashant. Let's hop on to the next question. I hope you're ready, Attorney Prashant.
Let's do the thing. I would like to put a plug in for all of your holiday gifts. Those are great stocking stuffers, right? So if I was watching this, I would be jumping at the opportunity to grab a power bank or a backpack or whatever it is, if it's not a stocking stuffer for anyone going to like a white elephant party, you could use it for that. So awesome. Good for you guys.
All right. I wonder, how are your preps, by the way, for the holiday season? Have you put up a Christmas tree already?
Oh, okay. So I've got a 20-month-old. And so if we put up a Christmas tree, I'm pretty sure she's going to just start pulling out all the lights and the ornaments and everything. So like, before she was born, like we did that and we would do all the decorations, but even last year we opted not to do it because she was just crawling around everywhere. And we were like, what if the tree fell on her? So just kind of like we think maybe in one more year we will do that. So that'll be interesting. But for the holidays, we'll be going down to my parents' place in Richmond, Virginia, and I know they've put up a tree. So it'll be interesting to see her reaction. And we're just hoping like the tree doesn't fall on her, she doesn't, start doing something else destructive. But yeah, that's kind of the
Well,
state of the situation right now.
yes, I think being protective is just the natural instinct, and I think you guys are the best parents, I would say. So, anyway, have a Merry Christmas, you and your folks out there and at your mom's place. And yeah, let's move on to the next question, Attorney Prashant. So, a PWD is job specific, or can it be used for multiple positions? I think we just, yeah.
We, so it it's job specific, right? So the thing about the PWD is you're basically saying that, hey, I'm going to sponsor this individual as a software engineer, and that software engineer position requires this specific set of responsibilities and this specific skill set and this specific education requirement and this specific amount of experience, right? So it can only be used to sponsor an individual for a single occupation at a very specific location, right? Very specific city or county or district, whatever have you. And it cannot be used to sponsor someone for multiple positions. Now, with that being said, what if someone isn't doing that job right now? And that's a question I tend to get from clients all the time, where they're like, hey, my employer wants to sponsor me for maybe a business analyst role, but I'm an operations analyst right now. Can I do that? And you can, right? If you can show you have the qualifications, you can do that, because it's important to keep in mind the perm labor certification is a promise of a future job. Okay. It is not saying that this is the job you're doing today. Typically, that's how it works. But keep in mind, it is a promise of a future job. So once you get your I-140 approved, and if you're, in India, your priority date's probably going to be current in like 30 years, which is unfortunate to say, but it's again a promise of a future job that once your priority date becomes current and you're eligible to file a 45 adjustment of status application, that at that time you will be doing this job, right? So it's
Mhm.
possible that the job requirements are different than what you're doing right now. But 99% of the time, that's not how it works, right? Like it's usually you get sponsored for the job you're currently doing, and that is the employment based sponsorship that you get. But just keep in mind, it is a promise of a future job offer. So if there are some changes, or some responsibilities that may not line up to what you're doing today, that's okay, as long as you're doing that once your priority date becomes current, whenever that is. And again, for India, massive backlog. For China, massive backlog. um, for most other countries, it's the priority dates are current.
All right. Thank you for answering that. And today we have Attorney Prashant Dubey with us from Dubey Law Offices, Washington, D.C., speaking with us about PWD. And yes, if you have any questions, we have his mail ID flashing on the screen, info@dubeylawoffice.com. Please feel free to mail Attorney Prashant Dubey about your doubts that you need to be cleared. And let's just go for a short break. I think this will be the last break, and we'll have another 15 minutes to go with the rest of the questions and some comments we'll be able to pick up maybe. So stay tuned, guys. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back to Immigration and Jobs Talk Show with me, Nipasa Pradhan, today. And we have Attorney Prashant Dubey from Dubey Law Offices, Washington, D.C. Thank you so much for being with us, today, Attorney Prashant, for sharing so much knowledge with us about PWD. And this is the second episode on the topic, employment-based green card, the process. I hope everybody out there is having a lot of fun and having the doubts cleared. So I can see a lot of questions. We will catch up on them, but let's move on to this next question without further ado. Can recruitment or job advertisement and PWD be started parallelly? And if yes, how do they know if a qualified US worker is not available?
Yeah. So it can be, right? You can do a prevailing wage determination and file the ETA 9141. And in parallel, you can also start the recruitment. So you can put the job advertisement into Sunday newspaper ads. You can put it in, a job posting type of website or a job board. You can do recruitment through a radio ad, for example, or other means that the Department of Labor has outlined. Now, there is risk associated with that because if you fall within the average timelines of where a PWD needs to, typically comes back as issued,
Mhm.
3 to 6 months, cool, completely fine. Even if you started the recruitment in month one or month two of the PWD staying pending, um, your recruitment and all of that work and effort and money you probably spent on doing it is still going to be valid for 6 months. Now, the risk is if your PWD takes a year to get approved. If it does take a year and you started recruitment in month one of the PWD pending, then you need to do recruitment again. Because again, all of those recruitment activities, they are only good for 180 days. So if for whatever reason you are falling on the 8 month, 9 month, 11 month timeline of PWD being issued, then chances are, you're going to be spending that same money, that same effort, paying the attorney and their lawyer fees again to help you with that recruitment phase, right? So that's the risk involved. It can be done. It's just not always advised. Another risk involved is if the prevailing wage comes in higher than what you started recruiting for, right? So you recruited for $70,000 a year. And DOL says no, based on this job description and everything in it, in this application, the prevailing wage is $80,000. You need to restart that recruitment again, right? So again, there's a couple risks in that if your PWD is processing for more than 6 months, chances are your recruitment and all of that effort you've done will expire within 180 days. If the PWD comes in higher than what you recruited with or recruited for, the salary amount you recruited for, then again, you need to do the recruitment again. So I don't always advise it. I tend to advise conservatively to my clients just to avoid any type of missteps because so much of this is outside of our control, right? Like we can guess and we make pretty good educated guesses on where the PWD would land in terms of the salary. but the processing time, that's up in the air. You just have no control over that. So,
Okay. And what happens, after the recruitment begins, maybe?
yep. So in terms of if the recruitment begins, let's say, um, and there is a delay in the PWD, you will have to do the recruitment again, right? So your recruitment is only valid for 180 days. And so if your PWD takes a year to get approved, chances are your recruitment, all of those efforts, all of that money is gone and you need to restart it. Again,
Okay.
the second risk is that if the PWD comes in higher than what you started recruitment with, then you have to start that process again. And that is, again, 60 to 90 days there, right? Where you need to do it again
Mhm.
in terms of that recruitment process.
All right. So the employers will require to spend the money and start the whole process all over again, right from scratch.
Yeah, at least the recruitment, right? The PWD is fine; it'll stay intact, but at least the recruitment phase, those 60 to 90 days would need to happen again.
All right. All right. So, folks, you don't want to suffer on that one at least. And let's go ahead and since we are running short of time, let's just jump on to the next question. So, this one is the priority date or GC process. And, what determines the priority date on a PWD filing date or PERM? Perm.
Yep. So the priority date is determined by perm filing date, right? So it is not the PWD; it is the perm filing date that determines your priority date.
All right. So, folks out there watching us on YouTube, Instagram, oh, sorry, not Instagram, YouTube, Facebook, and LinkedIn, thank you so much for dropping in your questions. And I think we have one more question to go, and then we'll jump on to the questions from the audience out there. So, this one is any online portal for beneficiaries to check the PWD status, or it's just the employer and attorneys?
Yeah. So one of the places that you can check on the PWD is the General Department of Labor website, right? If you just type in on Google PWD processing time USDOL, it will point you to a website that has all of the information about what month they're currently processing PWD applications and issuing determinations for. So that's one way to kind of check, like, hey, mine was filed in December 2023, but right now they're only working up until June or July 2023, for example. So that's one way you can check the processing time. There is a portal where you can put your ETA 9141 case number into that portal and check on the status that way too. But again, it doesn't really give you much information other than it's in review, right? The attorney, the employer, they can also go online. Let's say at the perm labor certification stage, they can go to the iCert website and they can take a look on there as well. And most of the time, all it says is that it's under review, right? So, really, I would say that public information that DOL has is just as good as anything else that your employer or your attorney is going to be able to see or provide you with.
All right. So, thank you so much for that. And I think let's move on to one of the questions from YouTube. This one is from Anthony Ella. With 20 months left on my H1B max out, um, where did it go? Sorry. Max out. If I switch from employer A to B, starting PWD permit I-140, would the 2 years be enough, considering the project end and GC process with employer A filed 4 months ago under EB2?
Yeah. So let's unpack this question a little bit, right? You've got 20 months left on the H-1B max out. So if you switch employers, employer A to employer B, starting, and I think employer B is starting your PWD perm and I-140 process. Will 2 years be enough? Considering the project and GC process with employer A filed 4 months ago under EB2. I might need some information there, but I'm going to just work with some assumptions here, right? So let's assume that employer A is the one that has filed, your PWD, your Perm, and your I-140. And they did that 4 months ago under EB2. So if they did that under EB2 4 months ago, you're still within the timeline or time period here where your I-140 could potentially be withdrawn or revoked, right? So I would say wait at least 6 months before you do an employer A to employer B transfer. Once you go to employer B, um, you can take advantage of the H-1B extensions beyond 6 years if you already have an I-140 application approved with employer A. Now, if your question is employer B is going to be doing this entire process for you, 20 months should be enough, right? I say 12 to 18 months. But if you land if you end up being somebody that, it takes 12 months just to get your PWD, then you could be looking at 24 months potentially, right? Um, Now, with that being said, you can get 1 year extensions if your perm labor certification application's been pending at least 365 days, right? So I would say at least try to get the perm application filed 1 year before your H-1B max out date, right? Just so you can take advantage of the 1 year incremental extensions that you can take advantage of.
All right. So I hope that's answered, Anthonyella. Thank you for your question. And I got this one from Chinu, Chinu. I hope I'm pronouncing it right. This is also in YouTube. Will job relocation, 30 miles from the current site, reset my green card process, or can the approved PWD be applied to a new perm filing for the different office after the shutdown of my current job?
Yeah, so they typically say, like, if you're within the same metropolitan area, it's completely fine, right? If you change cities, right, like you go from a San Francisco to an LA, for example, that's going to require a different PWD, a different perm process, right? Um, if you go, you know, within the same county and you're just 30 miles out, or within the same city, but you're just 30 miles out, that's fine. Typically, a good rule of thumb is about 60 miles. Anything beyond 60 miles is probably going to require you to redo that process, right? Even the
Mhm.
PWD, because keep in mind, the PWD is issued based on location. It is issued based on where you're going to be performing your job. Because again, a software developer in LA versus San Francisco versus Sacramento are going to be paid slightly differently, right? The wage levels are different even across cities like that, even within the same state.
All right. Thank you for answering that. I hope, Chino, your question is answered. And if you have any further queries, please don't forget to drop in your questions. You can also mail me. But I got two more questions to go before we wind up today's episode. So this one is from Sheikh Banu. When can I expect perm certification if my employer submitted the application in January 2023? Considering current Department of Labor processing times, and my H-1B expires in May 2024.
Yeah. I mean, a year is typical processing time for a perm, right? 8 to 12 months, I would say. With that being said, if you get audited for whatever reason, I mean, that increases the processing time by another 6 months. So there's variables in there that are just out of your control, right? Or very difficult for anyone to predict. Again, you can look at the general processing time and say, hey, I'll probably get it in a year. But if you get audited for whatever reason, right? You're probably looking at an additional 6 months, in your perm labor certification process. Now, the benefit to you is that your H-1B expires in May 2024. In January 2023, in January 2024, you are eligible to apply for an H-1B extension of 1 year, right? So if your perm labor certification is pending 365 days or 1 year, that does qualify you to extend your H-1B beyond your max out date by 1 whole year. So it's not like you're going to be in a situation where you need to leave the country or anything like that. So even if your perm takes a little bit longer to process, that's okay. Because you can continue extending your H-1B in 1 year increments while it's still pending.
All right, all right. And since we're running short again, I'll jump on to the next question. This one is from Dollar at Vlogger in YouTube. Employers PWD approved missing DBA on ETA 9141. Concerned about perm. Any experience with adding DBA later? Worried about complications. Advice is appreciated.
Yeah, I mean, if your employer went with an alternative wage survey and they didn't attach it to the 9141, that's obviously going to be like a problem. The US DOL at the perm labor certification stage, they're going to want to see, where the wage survey was obtained from. I would say follow up with me on that one, right? Because there's a lot to unpack in that, right? Like why didn't the employer include it? You know, did they, instead of doing the DBA, did they just opt for the normal OES wage survey that DOL does? So feel free to follow up with me. Happy to talk to you about it further.
All right, one last, which is like, how long can we extend the H-1B for 1 year?
How long can we extend the H1? Oh, as long as the perm stays pending. Now, chances are within that 1 year, it will get approved, right? Even if you do get audited, like audits don't take longer than about 6 months, anyways, right? So you should only have to tap into that benefit one time, unless something really far out of left field happens and your perm stays pending for a couple of years. But that's very, very rare cases.
All right, and I think the last question of the day would be from Jennifer, though there are a lot of you questioning us, and I hope that whoever is left, we will try to reply to your questions one way or another. Just keep following us in our handles everywhere, Immigrations and Job Talk Show. Subscribe to us, and we'll be happy to have the questions answered. So this one is by Jennifer on YouTube. On H-1B, applying for H-4 COS and EAD, plus husband's H-1B transfer. COS effective from January 18, 2024. Can I keep working on H-1B? Can I work with approved H-4 EAD status before receiving the physical card?
Yeah, so you can continue working on H-1B even while your COS application is pending. And even after it's approved, right? Hopefully you get your H4, H4 EAD approved concurrently. It'll come back with an effective date of January 18th, 2024, right? So you just take all of that paperwork back to your employer. They do the new I-9 verification with all of your updated immigration paperwork. Now, whether you can work with an approved H4 EAD before receiving the physical card is employer dependent. Every employer does it differently. I know some employers who are completely cool with that. And I know some employers who say, hey, we need the physical card before we can allow you to work. So that's something that, it's not really an immigration question. It's more like, what is your employer comfortable with in terms of, providing that I-9 paperwork back to DHS?
All right. Thank you so much, Attorney Prashant Dubey, for being so patient and answering all of our questions today, not only by us, but also the audiences out there who were, throwing questions at us continuously. Thank you so much.
Thank you. Appreciate you guys having me.
Thank you so much. And folks out there, if you have any further questions, don't forget to just mail your questions to Attorney Prashant Dubey at info@dubeylawoffice.com. And us as well. I mean, if you are looking for a project placement, you can just give us a call at 833-412-8472 or mail us at support@higheritpeople.com. You can also visit our website, www.higheritpeople.com, and also mail me at nipa@higherit.com. And I also have a number, 408-335-6444. We will be very happy to get in touch with you. And some of your questions may not have been answered, but look out for us and we will be very happy to answer your questions. Once again, thank you for joining us here at Immigration and Jobs Talk Show. It's me, Nipasa Pradhan, signing off for today. Y'all out there have a wonderful day ahead and keep that holiday spirit alive. Thank you so much once again. everybody.